Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom. Are you now or in the future going to step foot into a witness box? Whether you're going through a family court proceedings or going through domestic violence and going into the magistrate's court, this episode is a good episode for you. We've had many people reach out to us and ask us tips that we could give if you sit in the witness box. So today's episode, we're going to give you 10 top tips, and Mum is here to explain to you the process and why these tips are important. Welcome, Mum.
Hello, Laura. Hi, everyone.
Now, important for us to all remember that not everybody goes to court all the time. If you're listening today, maybe this is your first time ever in a witness box. Otherwise, you wouldn't be listening to this. And the only witness box things we really are aware of are the things like, you know, those movies like Jack Nicholson, I think that's famous, where he goes, "You can't handle the truth," to Tom Cruise. And it does seem very scary.
It does indeed. It's like public speaking with consequences.
Yes. So, Mum, what can you say to these people who feel like every single word they say is hanging in the balance, and what comes out of their mouth is going to mean the difference between them seeing the kids or not seeing the kids, or them getting a protection order or not getting a protection order? And if this does trigger anyone, please call 13 11 14 Lifeline or 1-800-RESPECT. But we won't be talking about family violence in particular. We will just be talking about sitting in the witness box and our tips. But Mum, how can you alleviate our lovely listeners today's fear of everything resting on their shoulders as they sit in that box?
Well, I think it's important to remember that your main evidence in the Federal Circuit and Family Court of Australia and Western Australia, of course, is already in evidence. It's in your affidavit, okay? And the affidavits of your witnesses, but it's in your affidavit. So what the barrister or solicitor who is questioning you is doing is just testing that evidence, they call it. So they suggest to you that something you said isn't true, or, you know, they put an alternative explanation to you. So they're really taking you through your evidence, but you've already done your evidence and it's in the court. So this is just kind of the testing and the icing, I guess, on the cake of your evidence.
And I think it's important to mention you're going into a room, a trial room, a courtroom or whatever, where this happens daily. So to a judge and to the lawyers, someone sitting in the witness box isn't a big deal. To you it is, but to them it's not. So it's the same like going for surgery. It's a big deal for you to go to surgery and you're on that little trolley and you're being wheeled in. It's a big deal. But to the surgeons and the nurses and everyone, it's no big deal. So I think that's important to kind of keep in the back of your head. This, although it feels like everyone is watching you and everything is so scary and important, to some people it's just their everyday job and they're probably bored.
And I don't know that I've ever been bored in court, but I'm a weirdo, I think, with that. But look, honestly, the evidence that you give in the witness box, it's important, but it's just a cog in the wheel of the case. Your representatives, your lawyers, are just putting the evidence forward through you, you know, but they've all got a plan. And they've all got a job to do. All
right. So number one, top tip, goes without saying, and there are a couple of simple ones. There's some more intricate ones later on, but the number one top tip, Mum, is what?
Tell the truth.
Be honest.
The whole truth. Nothing but the truth. Be honest. Yes.
And why is that?
Why? I raised you better than that, Laura, though.
I know, but it's important that people understand why is it important that you tell the truth in this situation.
Because you don't know where they're headed with their questioning. And if you slip in a little fib or deny something that actually happened, you don't know if they've got some hard, concrete evidence about that going forward. Also, too, I've been in the witness box twice. I reckon if I was telling fibs, I would have looked shifty. Some people just look dodgy when they're telling lies. And the judge, like you said, he's been in there or she's been in there day after day after day. And they're pretty good at picking a fibber. But also, too, if you tell what looks like a little white lie, I think you might say a little unimportant lie, like, no, I didn't give the kids takeaway that Wednesday. something like that, because you want to appear a certain way to the court. Careful, because someone might have proof. Someone might have CCTV footage that you went there on that night. Nothing hangs on it in your case, but now you've identified yourself as a person who will tell a fib. And then when the court has to choose between two bits of evidence, one from you, one from the other person, and there's no proof either way, they're going to go, well, this person lied before. And I think I'll have to prefer the other.
Our listeners will, of course, tell the truth.
Do you know the question I get asked most, and this isn't in the 10, sorry, but it's when they call you to the witness box, right? You go up, you sit down, you've got a glass of water, box of tissues that just tells you what kind of a morning you're going to have. And then they ask you, do you want to swear or affirm? And that can throw people, because they've got to swear to tell the truth, the whole truth, and nothing but the truth, so help me God, or they make an affirmation that they will tell the truth. And I've had clients think that if they don't use the religious one, that the judge will think less of them for not using the religious one, or that if they use the religious one, the judge will think they're over the top religious people.
Does it matter?
No, so don't worry about it. Just do whichever one feels right for you and move on.
Right.
Okay. But just be ready for that. When they give you this little card and they go, read what's on the card.
Okay. Oh, gosh, the poor.
Promise to spill the beans, the whole beans, and nothing but the beans.
Okay. All right. And where do they look when they read that?
At their note.
Okay. So they don't look at the judge?
Look up. Yeah, no? I wouldn't look up. No. Okay. You've got to be careful eye contact with the judge, because they're looking at you and sizing you up. They don't know you from a bar of soap. They've got your evidence. They've probably read all the affidavits, and their job now is to watch you and form a view about whether or not you've told the truth and your general demeanour. They can actually comment on your demeanour in the witness box.
So number 2, Mum, another basic one, but we've got to get to the basics. So listen carefully. So it's a barrister's job, right, to get the questions answered to prove their case.
Yep.
So do some people sometimes think they've heard a question when they actually haven't? But so does that cause trouble?
Jump the gun. Yeah, like I just did then. They can jump the gun. They think you think you know what they're going to say, and then you either cut across or you just blurt out an answer without thinking. Because remember, this can come out in a transcript, and what the person asked is one day could come out in writing, and what you answered is always there. And even if you say, I didn't really understand the question, or I missed that bit, or I thought he was going to say this, it doesn't matter. That it's on the record and you've done it. So just listen carefully. Just answer that question.
And then the next one is ask for clarification. So if you don't understand the question, because let's face it, some lawyers, it's like they talk in alien space language. Like, it's just ridiculous, some of the words they use. And even the names of the forms.
I'm feeling judged.
You should feel judged. But I'm wondering, Mum, and you're not, I love you, you're not bad at it, but what happens if they're using gobbledygook words, or even just some people use different words for different things? How do you ask for clarification? They've asked you the question and you've just gone, what the heck does that mean?
Yeah, but you don't say that. You go, I don't understand the question. Can you ask it again, please? And then they may try and make it a little bit more clear for you, or they might just say the same words. And if you still don't understand, say, I still don't understand. Do you mean this? Kind of just, They should be able to pitch the questioning at that to you, and they shouldn't be using legal descriptions and things.
What happens when a barrister or a lawyer gets in front of you, if you're in the witness box, and they just start like a big long monologue and there's like 5 questions in it, and they're just going, didn't you, or that, and just didn't you, blah, blah. Like, how do you answer a question like that?
Well, hopefully the person representing you will hop up and say, look, my client needs time to answer that question. There needs to be just one question per answer. If not, just say, I'm something like this. I'll try to answer that, but there seems to be more than one question in there. And then sometimes the judge will give a little warning to the barrister to just ask a question. Okay. In a perfect world, it's just like a ping pong game, like question to you, answer back, question to you, answer back, and they all should be capable of a yes, no answer.
the questions they ask should be yes or no answers.
If you're a barrister cross-examining, so your evidence is in, they are going to lead you through your evidence, and they will expect yes or no on most cases.
So, Mum, that leads us to number 4, which is don't try, and we kind of touched on it, don't try and guess the question or where it's going to.
Oh, yes.
So if maybe there's some contentious issue about choosing schools, or there's something about a particular suburb and the buzzword gets mentioned, and you immediately go, oh, or the person in the witness box is like, oh, they're about to ask me about this big thing that we're fighting about. So how do people trip up in that kind of situation, and why should they not try and guess where the barrister's trying to take it?
Because the barrister or solicitor will have learned to ask a set of questions which are pointing towards a conclusion or a submission they want to make. Mm-hmm. And maybe later on that they will put it all together and it will give whatever evidence they want. But when you're sitting in the witness box in the moment and you're asked a question, I've seen so many people, it's so apparent if you're sitting there, probably narrow your eyes a bit and you're thinking, where's this going? If I answer this, then what are they asking that for? If I answer that, what are they doing this for? I better not, you can see the cogs turn it. You can. And that hesitation and that sort of anxiety or desire to move it in one direction or not is so obvious to the court, when really most just answer the truth, because if you start doing that, you look dodgy. So just answer yes or no.
So really, you've just got to let it go. And one of the other questions we get asked a lot is, and I think it must run through people's minds when they're in there, and they're getting asked all these questions that make them feel or look horrible, because obviously they're presenting the other side's case. Does the listener's lawyer or does the listener's barrister get to ask you questions as well to clarify some of that, to point out your side of the story? So there is a chance for you to have your say later? Is that something that...
Yeah, there is. So you've given your evidence in an affidavit. It's been cross-examined by someone acting for the other person. And then your lawyers have a right of reply, or what they call re-examination. And they could stand up to clarify something if the yes-no answer got you in a spot of bother or misrepresented the case. So you don't be surprised if the person cross-examining goes, just yes or no, please, ma'am, just answer the question. Or, sir, one word answer, and they won't let you travel off. And some of the questions, Laura, are more like, it's not, did you have Macca's for dinner on Wednesday? It's more, you had McDonald's for dinner on Wednesday, didn't you? And, and it's yes or no. Right. And you often have McDonald's on Wednesday, don't you? Yes. And then they'll go, in fact.
I don't know why we keep using this McDonald's one, but we might as well stick with it. So you might be like, you want to say, yes, but it's because such and such was really exhausted and I was tired and it was a one-off situation or whatever. Not that there's anything wrong with going to McDonald's for like we're not judging, we're just using it as an example. So basically, if you find yourself sitting in the witness box and they've asked you a question that is they want a yes or no answer, and you want to say yes, but you're saying that later the other side, your lawyer or your barrister can stand up and get you to elaborate.
They can, but
should be in your affidavit.
But how are you going to know that the silly sausages are going to make such a fuss over takeaway dinner? But when I took the bar course and in my time as a barrister, we were warned to almost never re-examine. Okay, so even though you have that right, I think I've only seen it used a handful of times. If the question is asked a certain way and you answer yes or no, that may be where it sits. But it's just, so the barristers write their final submissions before they write their questions. So if he wants to be able to say that you do takeaway food more often than not, then those questions he's asking are so he can make that submission to the judge. Nothing to do with your case. It's just him preparing or her preparing for the other person's submissions.
So they work from the submissions they want to make to the judge, and then they figure out their line of questioning based on those submissions to get you to kind of like confirm what they want to say at the end. Okay, so it's a pre-planned battle, basically.
Too right it is. Too right it is. You've got no idea the way that the preparation that goes into it. But yes, a very well-known QC, who was my pupil master when I was at the bar, said, start with your final submissions and work back from there.
Okay. All right. So basically they're trying to get the other side's case across by asking you those questions. Another question I'd like to know, to avoid speculation.
Yes.
Is it okay not to know? So that's that's the next tip. Is it okay not to know the answer? If you don't know it and or in your head you go, oh, I'm pretty sure, I don't know exactly, but then you don't say that out loud. You just say an answer. But should you say, I'm actually not sure? Like, what do you say if you don't know the answer or you're not 100% sure?
Well, the truth is that you don't know the answer. I'm sorry, I don't know the answer to that, or I'm not clear on the answer to that. And they may say, well, what do you think it might be? And then you can say, but yeah, mostly, if you don't know, that's being honest. I don't know.
So if they're asking you, like, do you remember 2002? You might not remember 2002. So is it okay to say, I don't actually remember that very well?
Yeah.
Or, that's okay. Right. You're not going to get in trouble.
If you're honest, you're honest. And that no one's going to be critical of you for that.
What happens if they ask you a question you don't want to answer? Can you plead the Fifth Amendment? Is that an American thing?
It's not an Australian thing.
Okay.
It's not.
Okay.
And if it were, what would you think? You'd think, the reason I don't want to answer that is the answer's yes, isn't it? Yeah. And the court will draw that conclusion.
So you have to answer.
Yes. So unless your lawyer or the judge intervenes, and don't look helplessly at your lawyer. I've spent many years trying to avoid eye contact with someone in the witness box, because if they've asked a tricky question, it's between you and the questioner, right? And that could be the judge or the barrister, but don't look sort of helplessly at your lawyers to save you. If it was an objectionable question that you shouldn't have to answer, that they will be on their feet and saying, objection, Your Honour.
Really? That's so cool.
We do say that, yes, but you've only got a few grounds of objection. If they don't do it, then you must answer.
So what are the grounds of objection? Just throwing you under the bus here to list out.
Thank you, Rose, for that, yes. So one might be that you're seeking opinion evidence. One might be that you're asking the witness to conjecture and imagine what's going to happen. One other thing might be that you're badgering the witness, or that you've asked that question before and you've already got your answer. Or sometimes an objection is because if it's a multi-pronged question, then it might be too unfair for you to answer it all at once. Or if they move on to the next question, the barrister might say, Your Honour, I object. My client hasn't finished answering that other question,
Right.
So there are a number of grounds of objection, but they're around about, if you think of it in terms of the fairness of getting all of the evidence before the judge so that the judge can make a decision.
Do self-reps, can they object? But if your witness
is in the witness box, I suppose you could. Normally, I think the judge would more likely step in if it really wasn't fair,
Right. The judge can step in at times and object to things. Okay.
Yeah.
Okay. Yeah. So if your lawyer's not objecting, you got to answer the question. Okay. So let's just go through the first couple. So be honest, listen carefully, ask for clarification. You're allowed to do that. Don't try and guess the question or guess where it's going. Just answer the question. Otherwise, you're going to look shifty. Avoid speculation. So if you don't know, be honest and just say, look, I don't remember that exact thing, or I'm not 100% sure on the date, or
I don't know when that's going to happen, or, whether that will really be. Yeah.
Yeah. So if you don't know, you don't know. So be honest about it. And then also the next one is take your time. So how much time can you take? Because you just said, Mum, don't try and guess the question. So if you're sitting there shifty-eyed, looking around, taking your time, that's not what we mean. What do you mean by take your time?
Well, just a reasonable time. So take a breath. Okay, have a sip of water if you need to, and then answer the question. Don't sit there looking up to the right. You know how people, when they're wondering and looking around and squinting your eyes and thinking about that, tells the court that you're evasive, you're not being straightforward. So, it's about as long as with your kids, if you
have a little contemplation, think about the answer, and then answer. But don't look at your lawyer.
And don't take too long. If it's a simple question, then answer it with a simple answer.
Okay. All right. Number 8.
Hmm.
Be respectful. You are on show.
Yeah.
What do you mean?
Well, always be respectful to the judge, of course. It'll be Your Honour.
Yeah.
It'll be Your Honour when you're being cross-examined.
Do you say Your Honour or only if he talks to you? You don't speak to the judge unless the judge speaks to you?
Yeah, no, you don't ever talk to the judge unless the judge talks to you.
Wow, scary. Okay.
Yeah, you'll notice barristers don't either until he's ready for them.
Right.
Or she's ready for them. She'll go, yes, Mr. Such and Such, and that'll give them the key to talk. So no, you're not there to chat to the judge.
Right.
It's between you and your questioner. If the questioner is the judge, then you can answer the judge. If your questioner is the other person's representative, then you answer them.
What do you call, if it's a barrister or a lawyer asking you questions, do you even need to use their name or do you just answer questions?
So they'll normally introduce themselves. They'll go, oh, good morning, Miss Such and Such. My name is whatever it is, and I'm representative of your ex-partner today. And then you can either call them Mr. Such and Such or Miss Such and Such, or you can just say sir or ma'am, but be really respectful. And, one of the things that they like to do, barristers, is it's always counted as a win for them if they can manage to get you really angry in the witness box. And if they get you really angry and you show a side of you really didn't want to show to the judge, that's always a bit of a win. I think sometimes witness boxes bring out real personalities, true personalities, but the court's only got that to go on. They don't know you. They've read all your material. You walk in, they don't know anything about you. And so they're picking up on cues all the time, and they won't appreciate it if you get mad or sarcastic or snide at the barrister or lawyer questioning you, because they're all just trying to do a job. And the judge has got to come to a conclusion, and the barrister's solicitors, the cross-examination is to help get the right evidence before the court, and then they make their decision.
Easier said than done, Mum. Because
I know.
I know what you're saying, that it is their job to do. It's not them that have done the things, or it's not really them that are accusing you of it. It's their client, and it must be really hard not to get either frustrated, sad, angry, like especially for our post-separation abuse listeners, our poor little chickens that get this crap thrown at them all the time. It's just another day of getting crap accusations thrown at you. I can see how it would be very hard to not get frustrated, upset, angry. Do you have any tips for that? Even though you're not a psychologist.
Keep it in. Spare it till you go to the loo, or when you're in your car, you can say all the things you wanted to say, but you're playing into their hands if you get mad. And I find if you've had the same barrister or solicitor for a couple of cases, you can really get mad at them for the stuff they're doing. And it's like, why can't they see what their client's trying to do? And you roll them into the persona of your ex, but you can't do that. So be professional. I know that's so hard if you're talking about kids or things, but try and present a reasonably professional front. And the court is looking at you to see how well you regulate your moods.
So they might try and press your buttons. They might try and know what words to say to upset you, know what issues to talk about, or know when your personal core is being attacked. If you feel that you are a good mother and they are attacking your ability to parent, or if you know in your heart what happened, and you're in the DV court and they're attacking you in a way to make you feel like that you were a liar, like those things are attacking your inner core. And that can be really hard to hold in, but maybe you could channel Ned Flanders. I know this is totally left field.
What does Ned Flanders do?
I don't know if anyone's watched The Simpsons, but Ned Flanders, Homer Simpson abuses him verbally, physically, you name it. That poor guy, he's had his house taken off him. He's, everything in the world has happened to this guy, and he only cracked it once, but every other time he just copped it on the chin. And he just Ned Flanders it up. So I don't know if anyone has watched The Simpsons, but be like Ned Flanders. Don't be like Homer, who just loses it within 2 milliseconds of anything happening. be a Ned Flanders in that witness box if you can, or a Maud.
Yeah, it's like being like being a superhero if you can hold it in. I mean, it's practically impossible. You think the court would understand that, but they don't. And, you're literally being judged.
They see it day in, day out. It's the same. You go to surgery. They see day in, they don't understand. Some people are desensitized why you're scared. Same with courts. People see this all the time. They're desensitized to this big, scary situation. All right. So let's get into number 9.
Yeah.
If you get upset, if you can't Ned Flanders it, if you can't superhero it, what do you do?
If you need to, you have a drink of water, blow your nose. If you need a bit of time to regain your composure, the court often says, would you like some time to regain your composure? Yes, please. So you can ask for that. You can ask for a comfort break. Or,
does the judge do it, or does the lawyer do it?
Sometimes the judge will say, would you like a break, Miss Such and Such? Or the lawyer may say, if this is upsetting, would you like to have a break for a while? Because there's no benefit to anyone if you're so upset you're incoherent, and it might taint actually the evidence that you give. They might say, oh, well, she was very upset at the time. Sometimes your lawyer might intervene. So what I suggest you do is if you're in there and it's really getting to you and you're very upset, ask the barrister who's questioning you, could I have a break, please? Can I just have 5 minutes? And then they may give that to you. I think the court's pretty reasonable about breaks like that. So 10 minutes if everyone agrees.
Are you allowed to, do you leave the witness box then and go to the loo, or do you?
Yes, but you can't talk to anyone. You can't talk to your lawyer. If you're in the middle of cross-examination, say over lunchtime, if you're halfway through being questioned and it's lunchtime, they will give you a warning to not talk to your lawyer, not talk to any of the other witnesses. It's a very lonely time. So when you go to the loo, you've got to, or it's what you're going to leave your phone behind and just do what you have to do and come back, but don't talk to anyone else.
What happens if your cross-examination isn't finished and the day ends and you have to come back another day? Because some of our members have got trials that go for days. So what happens then?
You can't talk to any other witnesses about it, and you can't talk to your lawyer about it.
Wow.
And over the weekend, imagine that.
Jeez.
Over the weekend, and that happens. The court tries really hard to not have people hanging overnight with cross-examination because it's so isolating and terrifying. And you can really ruin the case if you talk to one of the other witnesses about what's happened to you in court. Because what the court does, they don't want witnesses to collude with each other, talk to each other. They don't want you to give your friend who's going to give evidence for you, oh, look out, they're on to this topic, or, they know I did this. It's a bit, you can have a break, but it's quite a lonely break.
And witnesses, they're not allowed in the room while you're being...
No, they're
witnesses
in the
got to
room.
be out. Yeah,
until they give their evidence.
Just when finishing off with number 9, if you're upset, you can ask for a break. But a good point to think of is you don't want this to drag on over another day or over lunch or whatever. So the only way through it is through it. That's what you've said before, Mum.
Yep.
To people before. So remind yourself you can take a break, but you are going to have to get back in there and you're going to have to do it again. So the only way through it is through it. So if you can, try, but if it's affecting your ability to think or answer questions, of course, you want to be asking for a break. Now, Mum, what does reading evidence mean into the what?
Into evidence.
Yeah, what does that mean?
So the court can only rely on evidence, and that evidence is in your written affidavit.
Right.
And by your answers in the witness box. But sometimes there are documents that aren't attached to your affidavit, and they might be things that have come through by subpoena, but they need to be part of the record of the trial for the court to make sense of it. So if you're going to read a document into evidence, the person who's cross-examining you may give you a document and say they have to put it through a witness, right? They can't just say, oh, Judge, I found this one and I found this the other day. This must be relevant, this document. What they do is they ask you do you recognise this document? Yes. What can you tell His Honour or Her Honour what it says? And they might ask you to read it. And then they say, I tender that as Exhibit A. And then that piece of paper gets into evidence. If you say, I've never seen it before in my life, and they haven't got anything else to hitch it with, it may not make it into evidence. But generally, they're putting things to you to get it into evidence in a tender bundle or as a tender document. And there's another thing, when they say, I put it to you that you did get upset, they'll ask questions, yes, no, yes, no, yes, no. And if you answer, so let's go back to having takeaway. So you had takeaway on Wednesday night, didn't you? No. I put it to you that you did have takeaway on that Wednesday night. What they have to do there, what that is they ask the question. If it's not the answer they think is true, then they have to say to you that they're going to say something different. And it doesn't mean, when they say I put it to you, what they mean to say, what it really means is we're going to say, or we say that you did, and then most people go, oh, well, I didn't. Well, I did. But there's a rule in evidence that you can't put a submission to the judge at the end of the trial that hasn't been put to the witness. So putting to the witness or asked of the witness.
Right.
So again, it's all this ticker box and lists of things they're doing.
So it's just following rules to get stuff into the case. It's got to go basically through a question to you if it's not in an affidavit or
and just like that, like anything in there, just answer honestly.
Okay. I put it to you. That's such a weird thing to say to someone.
I've heard that. It's just, it freaks people out if the first time they hear it's when they're sitting up there and he says, I put it to you that you did do this. And they're like, what do I do with that? That's not a question. That's not.
Well, you're wrong. You can't say that.
Go, well, I didn't.
Okay. But is that what they should do?
But you don't have to answer anything. They're just putting it to you, and you people normally just, well, what's that mean? I don't know.
Okay. Let's go.
So they're just following their things they have to do,
Gotcha.
ticking all the boxes.
So, Mum, number 10 is who's in the room. We're going to talk about who's in the room, but you're saying just focus on the person who's asking the question or the judge if the judge talks to you. But you don't look at anybody else. And we did talk about, you did say, don't, for goodness sake, look at your lawyer. Don't look at your lawyer. So why are we just focusing on the person asking the question?
Well, you need to be present, 100% present to listen and answer properly. You don't want any absent-minded responses that are taken down, and used against you. The other thing is you may have people in the room, your family members or something who've come to support you or your new partner, right? And you don't want to be distracted by them, looking at you and when you've been asked a question by a barrister. This is your case. You're in there. This is your evidence. But you might say something to your witnesses if they aren't giving evidence and they're coming as a cheer squad or support. They have to follow a few rules and you're the one that has to tell them, right? They need to sit quietly, no eating or drinking in the court, no eye rolling. When early days, I was acting for a woman and I thought we had a wonderful, strong case. And when the judge made his decision, I was a little bit astounded, but he actually said in his reasons, he said, unbeknownst to Ms. Such and Such's lawyer, her new husband was sitting behind and apparently pulling faces and eye rolling. And she had no idea either. And it just ruined the case. And from the minute they walk into the courtroom, and you too, if you're walking in there every day for your trial or one day, the minute the judge sees you, they are forming opinions about you. And they might, she's one of those. He's one of those brash types, they're
already starting to categorize you into stereotype people that they see from day, which I guess it's the way you process things. Unfair though. Yeah.
But don't give a bad impression. It's a very serious matter. No giggling.
You're saying don't add complexity or potential boo-boos to your case by having 20 people sit in the support area cheering you on or laughing or giggling or booing or, just...
Or dressed inappropriately or looking bored I mean, it's a real two-edged sword, that, and you're likely to have the judge throw them out.
Right.
So, but even if they're in there having given evidence, right? Even if you've finished your evidence, you've sat down, your witnesses have given their evidence, so they're all in the back of the court, and now the other person's being cross-examined by your lawyer. Again, don't you or your other people react. You really need a stone face, look down. If you can, don't death stare your ex in the witness box. Don't have them jostle. It's just awful.
So the judge looks at your reactions to the other person being in the witness box as well.
Yeah.
So I have heard someone say that their lawyer told them to just write notes, and then that way they weren't looking at the person in the witness box at all.
Even if all your writing's I'm a teapot, I'm a teapot, I'm a teapot.
Maybe don't write that in case you go in the witness box. Did you just write I'm a teapot 100 times? I put it to you.
You've been in the witness box, remember. But no, it's terribly important. It's a serious occasion. You've got a very high-paid judge, with whose time is extremely valuable. You've probably got, if you've got barristers each and solicitors each, that's another 4 people involved. They are all dedicated to your case, and is a somber and serious occasion, and you have to treat it accordingly.
Okay. And I guess it goes without saying, wear appropriate clothes. Don't wear outrageous things, which sounds sad, but just be really sensible, really boring. Black, navy blue. Yeah?
Really, honestly, that's right. And I remember years ago, a lady turned up for her divorce and she was going to netball training afterwards, and she was wearing a netball uniform, and the judge refused to hear her matter for the divorce, sent her out to get changed. We sometimes used to get admonitions that, it's not a day at the races. It's a serious, important occasion, and you should dress respectfully. Yeah. I don't mean you all have to wear stockings, the women, I mean. And the men may not always wear a tie, but honestly, if you've got a shirt and tie and a suit coat, ladies, if you've got a respectable frock, that will, or a trouser suit or something.
Yeah. And not short skirts. All of that's just going to help you. Not big, ridiculous, outrageous slogan earrings. Just really tone it down, because every little thing is going to be looked at by the judge. And, you do hear
it's a distraction.
You do hear people saying, don't wear this for this judge or don't do this for that judge. So there are foibles and rumours, and I don't know whether it's true or not, but just make sure you talk to your lawyer about your outfit. Is this appropriate? Is this okay? So let's quickly go through these again, Mum. Be honest. Listen carefully. Ask for clarification if you don't understand. Don't try and guess the question. Avoid speculation. If you don't know, you don't know. Your lawyer or the judge doesn't object, you have to answer it. Take your time. Be respectful. You're on show. The minute you step in, the minute you leave, and even when you're sitting down watching somebody else in. If you get upset, the only way through it is through it, but you can ask for a break, and focus only on the person who's asking you the question and ignore everybody else, and don't look at your lawyer. Yeah?
That's right.
Now, Mum, we were going to put one in and we didn't put it in, but I think we could just quickly mention it. And because this is legal education only, this is not legal advice, and everything, this is not your strategy for your court case. Speak to your lawyer. We're just trying to give you some tips to calm you down, to talk through the process so you can get it in your head, the situation, because it'll be less scary. But Mum, some people say it's important, but it might not be important for your case. So check with your lawyer. But to be brief, to have short answers. Can you explain why people say that?
I think that it's usually a question is asked of you to elicit a yes or no answer. If the barrister or solicitor is very good at cross-examination, you'll never get anything more than that into evidence before they stop you, or they'll ask you yes, no questions. But you don't want to, if they don't control it, you don't want to keep talking and dig yourself into a hole. Don't go rambling on. So if they say to you, you don't think much of my client, do you, Miss Such and Such? And you can go, well, no, but he did do this and he does do that. And would you feel that way if, like you can just run off at the mouth and your self comes through? And actually, if a barrister or solicitor is letting you do that, it's because you're digging yourself into a hole.
To stop yourself,
okay.
Pull yourself up.
Yes.
If the barrister's letting you talk, that's a bad sign if it's not your barrister.
It is. Because if it was damaging the barrister's client's case, they would stop you. Just answer the question, please, witness. But if they're letting you ramble on, what one judge called going off on a frolic of your own, then it's a bad sign. You might think you're doing well, but actually.
That's so hard if you are a talker. So yeah. So sometimes it's a good idea to do that. Other times it's not. We're not giving you legal advice, but that's a good reminder. No. And the other one, Mum, is can you tell us a bit about this barrister's momentum that people should be aware of and any tricks that they can use to stop a barrister's momentum? When
we were kids, and I think when you were kids as well, you'd have these jokes where you get people to repeat after you something that was pretty obvious.
Yeah.
I can't remember the joke. Is they will ask you a series of questions to which the answer might be yes, or it might be always no, and you get into a little bit of rhythm and they'll ask and you say no, they'll ask and you say no, and then they might pop something in when you really should be saying yes and you say no because you're in that rhythm. So that's why we want you to think about every question.
Right.
And the rhythm should be your rhythm. That's one thing you have got a little bit of control over. And again, if you think about every question before you answer it, just give it a beat. I mean, you don't want to be a long time, but that should stop you being trapped into those things. The other thing barristers do is they will ask you some questions right at the beginning of the evidence and then ask you one or two towards the end of the evidence and then be able to draw a conclusion, which is called closing the gate in our advocacy world, from those comments that were so far apart that you haven't remembered probably what you said, an hour and a half ago in the witness box. But they've got a plan and they'll ask all the 4 questions they need maybe to make that point, but they'll sprinkle it through all of your evidence. So yeah, you just have to think about everything quite carefully before you answer.
And I think that if someone is setting a pace of the way that they're speaking, how the conversation is going, you try and match it because it seems to be, I'm in this place, it's a different place. They're talking this fast, so I should talk this fast. But you need to take your power and control. And if they're asking bang, 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 bang questions and you're starting to get a bit nervous and you're starting to realize that your questions are too hurried and answers are too hurried, you can pull it up. You're the one who's got the power in this. Your response, when you can respond when you're ready. And if you need to take a deep breath which the judge will pay attention to, so don't take a deep breath on a question that, you think might look dodgy. But this isn't how to win friends and influence people moment. This is for this barrister that you're dealing with, or this lawyer. This is you answering questions, being respectful, but also taking it at your pace and not letting them let you go out the garden path or leading you into saying something that you didn't mean to say. Is that about right? Huh?
That is.
Now, Mum, I'm going to ask this one more question and then we're going to go. Has a case ever been made or broken by a witness box situation, or is it a combination of everything that makes or breaks a case?
I can't speak for every case, but for me, in my career, I think that there was maybe one time, maybe the stuff in the witness box just undid everything this person had said, and they were bragging about it, and we just let them keep talking, and that sunk the case, and we're no further questions, Your Honour, because everyone in the room except this person knew that they'd just sunk the case. But more often than not, it's incremental, it's polite, it's almost, you can't really notice it happening. And there's none of these like TV witness where they crack up and go, yes, you're right, I did it. Or no, you're perfectly right, he should have the children full time. That doesn't happen.
So it's never. And one question that does get asked pretty much without a doubt in children's custody cases, I've heard and I've been told, is, do you think the other parent is a good parent or something? What's the question that always gets asked?
Normally, can you say anything good about the other person?
That's the question.
Well, I only heard this after the case. I wasn't there for the trial. And she said, yes, he went back to South Africa. Has he ever done anything good? Yes, he went back. And that just sunk the whole case. So don't do those things.
So people need to be able to say something good about their ex, even if they're a giant poopy bum.
Oh, you can sound like you're prepared.
Yeah.
But so you can, we do warn them now. We do warn people now because that often gets asked. But you don't have to be disingenuous or untruthful about it. You just, try and think of some things like, oh, maybe, they play sports together or whatever it was. And never, never, never make a joke in the witness box. That woman thought she'd made a joke, but it wasn't. And you'll never see solicitors or barristers making jokes.
No.
The only person in a courtroom who can make a joke is the judge. And we all laugh because we must.
That's a bit unfair, but
I think of it more as their office. So they come in every day to go to work. They sit in their chair. They've got all their computers and documents and you're in their space. Okay.
Yeah.
And they're letting you in so you can give a bit more information about what it is they've got to decide. So, yes. As I think someone in law wrote that law students should refrain from trying to make judicious humour, use of judicious humour, because law students generally can't tell the difference between judicious humour and the other kind.
Right.
And the only person who can make a joke is the judge. So, don't suddenly make it. You might be really nervous and giggle when you're nervous, but you're going to have to control that.
Right.
Okay. Carry something in your pocket or, something to keep you calm, a little pebble to remind you.
Yeah. Yeah. Or if you're going to wear a badge or something, put it on the inside of your jacket and make sure it doesn't say anything worse in case the barrister says, show me the badge that you're wearing inside your jacket.
Yeah. And there was a period of time there where people were wearing different shirts, T-shirts with slogans on the back that the judge couldn't see.
Mama.
Yeah.
Don't do that.
And
either.
that was just very poor form. And I'd be surprised if their lawyer would have continued acting once they'd seen it.
And when do you know it's over? When do you know your time in the witness box is finished?
But usually the barrister will go, Your Honour, I have no further questions for this witness. And then the judge will usually ask your lawyer, any re-examination, Miss Such and Such? That means, where you might have missed a point or it sounds bad. If they don't, say if your lawyer doesn't want to ask you any further questions to clarify things, then the judge will usually say you're excused. And then you can go down. And then you can talk to people.
Once the judge has left the room.
Oh, yes. But, during, when you've stood down, usually there'll be a break. Sometimes it's in the middle of the morning or afternoon and that they just called the next witness. And the barrister for you will say, I now call Ms. Such and Such as a witness, and then they go in and get their grilling. It's usually the applicant and the respondent, the two parties, who get the longest time in the witness box. And then, of course, there'll be family report writers and stuff.
Okay.
But, yeah.
All right. So just a reminder again, be honest, listen carefully, ask for clarification, try not to guess the question. If the lawyer doesn't object, you have to answer. Avoid speculation. It's okay not to know. Take your time. Be respectful. You're on show. If you are upset, the only way is through it, but you can ask for a break. And number 10, who's in the room, just focus on the question, on the person who is asking the question. And of course, you always be respectful to the judge. And no further questions, Mother.
Well, thank you. Am I excused?
I don't know. You're the mum. I am not a judge or any of those kinds of people. But thank you so much, Mum, for your time. And to anybody who's listening today, we've got lots of other episodes you can go and listen to where you can feel a little bit stronger about what you're about to do. But I think just these tips may help, and remembering you've got this and we're here for you. Yeah. And make sure you organise something to do that afternoon, whether it's just go to bed and someone looks after the kids, or whether it's, I don't know, go and get a massage, or you've got a friend coming over so you're not alone. I think that's really important because it is a big emotional roller coaster. trials, let alone being in the witness box. But thank you, Mum, for everything that you've shared with us today. And we look forward to talking to you again next week.
Okay, bye-bye, Laura. Bye, everyone.
Bye,
Good luck.
everyone. If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording.